All of my children have been robbed of their childhood innocence. The emotional, physical, and financial repercussions of the crimes that she has committed will last for years. The children and I are asking that Ms. Session remain in custody until she can face a jury of her peers and pay for the atrocities that she subjected my children to.
An Oregon teacher and her parents are behind bars, facing multiple charges in connection with just absolutely horrific child abuse. Authorities say Sarah Session, a special education teacher, subjected a young child to unimaginable cruelty, forcing him to eat his own vomit, beating him with a curtain rod, and withholding food and medical care. We're going to dive into these shocking details right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. A former special education teacher is now in jail. Why? Because she is accused of abusing a young child. And when I say abuse, I'm talking allegations like forcing a child to ingest lethal amounts of sodium and even attempting to murder the child. Now, here's the thing about this. As shocking and disgusting and disturbing as that is, these allegations, they don't stop with her. They don't stop with this teacher. No, rather, her parents are also allegedly involved. We're talking about 33-year-old Sarah Session, a licensed teacher from Oregon, who was arrested alongside her parents, Gary and Paula Hardenberg, after authorities launched a manhunt and tracked the couple down in Coos Bay. And get this, the family now faces reportedly 28 charges in total related to the alleged abuse of this young child. And we learned some absolutely disturbing details from court this week that we're going to get into. Now, here's what we know so far. So according to prosecutors, this abuse allegedly began in June of 2023, more specifically, June 1st. It went all the way until apparently February 6, 2024. And this is because we believe that Sarah Session apparently had sole responsibility for this child who apparently required specialized education and care. Now, Session seemingly had the necessary qualifications to provide care like this. However, according to prosecutors, instead of administering the proper care, this child was subjected to just absolutely horrific treatment. This child was allegedly kept alone in a room with no bed, only a mattress to sleep on, deprived of food and water, and repeatedly physically harmed, including being struck with a curtain rod and a window stopper. And even more disturbingly, and I'm sorry I gotta say this, I just think it's important for you to understand the full picture of these allegations, so I'm sorry I have to say this, but prosecutors allege that Session forced this child to eat their own vomit. It's disgusting. It's disgusting. It is horrifying. There's really no other way to describe it. And it's honestly one of the most disgusting things I've heard in some time. Now, these details, they were outlined in an indictment which was reviewed by the local outlet, The Oregonian. But you remember I said that her parents were caught up in this? You remember when I said that? Well, the question is how? So apparently they lived nearby, and according to the indictment, they were fully aware of what was going on, this alleged abuse taking place. And prosecutors allege that not only did Gary and Paula Hardenberg know about this abuse, but they also attempted to cover it up. Authorities even claim to have video evidence showing the Hardenbergs cleaning the child's room after Session was arrested. This has also been reported by KTVZ 21. And also, the state alleges that they lied to law enforcement, misleading them about the extent of what was happening. So this investigation into Session's alleged abuse began in February of 2024, when, according to KTVZ, that child was rushed to St. Charles Bend Emergency Department. Unresponsive, the child was later transferred to Oregon Health and Science University Hospital in Portland, and doctors reportedly discovered sodium levels in this child's body that were so dangerously high that, in the words of the prosecutor in this case, they were, quote, the highest ever recorded. According to Deputy District Attorney Stacey Neal, who spoke at a recent arraignment hearing, that child was near death. And medical professionals confirmed that that condition was consistent with the child being forced to ingest excessive amounts of sodium. And court records indicate that that alleged victim, as if this couldn't get any worse, is so young, under the age of 10. This has also been reported by KATU2. By the end of February, after a lengthy investigation, prosecutors announced that a grand jury had indicted Sarah Session on 19 charges, and that includes attempted murder, assault, criminal mistreatment, Her parents, Gary and Paul Hardenberg, they were charged with criminal mistreatment, tampering with physical evidence. Paula also faced an additional assault charge. A felony warrant was issued for the family. Authorities eventually located them in Coos Bay after hotel staff apparently recognized them from photos and contacted the authorities. Session and her parents, they were arrested at 2 separate locations. What a story, right? Look, the stories we cover on Sidebar, I feel, highlight just how scary the world can be at times and how important it is to protect yourself. Talking about that is particularly true online, especially when it comes to protecting your personal information. So whether it's spam, identity theft, online stalking, our amazing sponsor, Surfshark, offers an incredible solution to these issues with their alternative number feature. So this service, built right into the Surfshark app, lets you create an entirely new identity, complete with a random US phone number, email, name. This way you can keep your real number and details completely private. It is great for signing up for services or websites that maybe you don't fully trust. It ensures that your personal phone number stays free from spam. And also, with alternative number, you don't have to give your real phone number to strangers while shopping on various marketplaces. So if you're ready to take your online privacy to that next level, check out Surfshark in the description below or visit surfshark.com/alt-sidebar. Sign up now, get Surfshark's alternative number feature plus 4 extra months of Surfshark. Now, before we go any further, I want to bring back onto Sidebar Dan Schorr, former criminal prosecutor, municipal inspector, and also the author of, Dan, my understanding is a book that's doing quite well right now?
Yeah, I think thanks to coming on your show, Jesse. I've written 2 political thrillers about the type of cases that you talk about, and people can learn more. They're called Final Table and Open Bar, and people can go to Substack, see my newsletter, and learn more about it. But I cover the types of cases that you talk about because they're so compelling, disturbing, and I base the fiction stories on real-life cases that I've investigated.
I wish this was a fake story, but unfortunately it's a real one, the one that we're covering right now. What are your overall thoughts on this?
Well, one thing that keeps coming back to me when I look at these facts is that as a parent, the people you fear instinctively in the media are strangers coming to hurt your children. And in reality, from the cases I've prosecuted and investigated, it's the caregivers, the trusted caregivers, the people in positions of trust that more often are the threats. And people are always looking out for the stranger in the playground grabbing their kid or something like that. But unfortunately, most crimes that are child abuse are done by someone in a position of trust, as this person was. And that's very disturbing.
And I can't 100% confirm the relationship here between Session and this child. We can speculate about what that might be. But the charges, what do the charges tell you in terms of filling in the gaps of what they're alleged to have done here?
Well, we definitely know that this person was in some position of trust with this child, because if they were allegedly forcing them to take all the sodium in and eat their own vomit, that a stranger is never going to be in a position to do that on an ongoing basis. It has to be someone who has some kind of interaction with the child where they're alone, because if anyone else sees that, obviously they're going to put a stop to it. So we don't know all the details. Every defendant is innocent until proven guilty, but clearly this person had access to someone who we know was significantly hurt. Whether it's ultimately proved that it was by this person, we'll see what the court system says, but we know this child was near death, as you said, and it was consistent with that type of mistreatment. And unfortunately, this is not an isolated case. It is incredibly shocking and disturbing, but as a child abuse prosecutor, I've seen a lot of cases where people who are caregivers in a position of trust do take advantage of that for an assortment of reasons.
What are those reasons? Let me rephrase. If these allegations are true, okay, why do we see adults abuse children like this in this way?
That's an age-old question. Why do people hurt children? Sometimes it's because they're in a position of power over someone and they want to exercise that power. We've also seen a cycle of violence across generations, that a lot of times people who commit child abuse were abused as children themselves, and they either see that as the way children should be treated because that's how they were treated, or they're taking out aggression based on what they experienced. We don't know about this particular case, but I've seen that in a lot of other cases I've investigated and prosecuted where defendants were abused as children and they pass that on to how they treat children. And sometimes the caregiving of a child can be very frustrating, and people have to really channel that frustration into productive ways of caring for someone. And some individuals just don't do that. When they get frustrated, they act out through retribution and sometimes violence or other manners of mistreatment that you've outlined here. And unfortunately, that scars someone for life.
These are some of the worst cases that I cover, because you're dealing with victims who are so defenseless, and particularly if a child who needs special care, it just makes it even more horrifying. When we talk about attempted murder, though, that stuck out to me, right? So I've covered a number of child abuse cases or alleged child abuse cases where the charges are child neglect, child abuse, assault, attempted murder. Talk to me about the decision to charge with attempted murder and maybe the complications for prosecutors to prove that.
Sure. Well, it's always challenging in cases like this to prove intent. Did the person intend to kill someone? Often, some states have statutes where the attempted murder can be based on a recklessness, where someone has a depraved indifference to human life and their actions then led to someone facing death. So it depends how the statute is constructed. But if they're showing that the person intended to kill the child, that was their goal, sometimes you can prove that through the extent of what they did. If you gave someone a certain amount of sodium that is lethal, you infer intent to kill there unless there's another explanation. What is the other explanation? The other explanation may be that they were trying to hurt someone in a really terrible way, and that may not make them innocent, but maybe it'll say that it wasn't attempted murder, but it's really not going to stop someone from being put in prison for a long time.
You have parents and their daughter being charged together. Is that a complication, charging a child and parents together? I mean, would they even go to trial together? Would their cases be severed?
Well, the parents, part of the charges are with trying to hide or distort some of the evidence. So the allegation seems to be that the parents were trying to help their daughter who is accused of something or was going to be accused of something. They can be tried together. Very often when some people are charged with doing something with evidence related to a crime, they have a plea bargain and they're used as witnesses against the other person. That would be harder to imagine here since they'd be testifying against their own child. So
you think that would happen? You think that they would testify against her? They're facing, serious charges, but not like what she's facing.
Well, that's a question that they're going to probably have to face. If these allegations are true, I'm sure they'll be offered a plea bargain where they get some reduced prison time or maybe no prison time in return for testifying. They would have to make that decision. And some people may say, I'd rather go to prison for the rest of my life than testify against my child. We don't know. But this is how prosecutors build their cases. They charge people who are complicit in hiding evidence, and then they try to turn those people, if possible, to get more cooperation against the main target of the investigation. I've done that many times as a prosecutor, although I don't think I've ever had a parent who was the person who we're trying to get as a cooperating witness. But that may be one way this plays out.
By the way, Sarah Sessions, she's facing multiple counts of assault in varying degrees. How does the prosecution differentiate between those charges when they present it in court?
Usually the different degrees are based on either the intent, whether it's an intent to cause serious injury or just to cause injury. It may be that there were multiple instances of physical violence or harm to the child, and some rise to physical injury that would lead to a likelihood of serious injury or death, and that would be a higher charge of assault. So when we see multiple instances of abuse, that's very common to charge many assault counts, some in a higher degree than others. They all have different sentencing. And then if the defendant is convicted at trial, then you would have a judge have to decide, are we going to run those sentences consecutively, meaning one after another, or do they run concurrently, which means that they serve them all at the same time? And that could be a much shorter sentence. So that's ultimately up to the sentencing judge if there's a trial, but we're a long way from that.
And it's so specific. It's so specific how the prosecutors seem to know what happened here. Why do I say that? Paul is charged with assault in the second degree. Her husband, Gary's not. To have these specific charges, it seems to me they have a better understanding of what was going on. And I'm curious how they have that information. And what does it say to you that Paula is charged with assault, but Gary isn't?
Right. And prosecutors never reveal all the information at this point. So we don't know. But maybe it's the case that someone else, the other person, was helping out with finding out what happened. Or maybe they found that the actual criminal acts were done more by this defendant and not a husband or someone else. So the prosecutors know that information. They don't have to reveal it at this time, but they may think that she is the main culprit, the main abuser here, and other people were helpful in some ways that are still criminally illegal. But if they could gain their cooperation, it helps them build their case.
And there's also that coercion charge as well. Do you see that typically in these kinds of cases?
Absolutely, you can. It really depends on the relationship with the parties, the victims, the defendant, how they maybe are manipulating each other or how other people are helping out. So, and a lot of times these extra charges are used as leverage also. Most cases, as you know, don't go to trial. They plea out in some form, especially when there's really powerful evidence. It's very rare for someone to go to trial as a defendant when it's overwhelming evidence. So often the prosecutors will have extra charges that they think they can support, but maybe they're doing it as leverage. I know that's one thing that the defense bar often criticizes prosecutors for, is overcharging and then working back to a plea bargain. So that could be the case here. We just don't know.
And here's something else I wasn't entirely clear about. So according to KEZI 9, they reported that these criminal charges against Sessions, They were initially filed in April of 2024, but then they were dismissed pending further investigation, and then the charges ultimately were filed against her and her parents this week. Why did that happen?
We don't know at this point, but I know as a prosecutor, sometimes you're bringing charges and then you realize you need further investigation, or maybe there's a procedural element of one of the charges that hasn't been satisfied yet. So you want to go back and do more research, or maybe you have just gained the cooperation of another witness. We talked about the parents, then maybe there's another witness and you want to take a step back, see what information you're getting from that cooperating witness, and then come back with fuller account of what happened in the charges. So those are some possible reasons why that may happen. We don't know yet, but that's how it usually plays out.
By the way, prosecutors wouldn't want to take this to trial because would they have to put this young child on the stand or no? I mean, again, I don't know what the limitations of this child maybe testifying are. And plus, I think you would try to want to avoid any alleged child victim from taking the stand. Could they prove their case without having to have this child testify?
It really depends on the evidence. Certainly you want to avoid a child having to testify often, and this is one of the dangers of child abuse. The child is the only person who witnessed the misconduct, and you need the child's testimony to prove it. But if there are overwhelming medical records, which you've talked about, and if maybe there's a confession or a partial confession from this defendant or other witnesses who knew what happened and talked to law enforcement about it, then maybe you could construct a case and prove it beyond a reasonable doubt without the child.
Well, if a child, any child in any case, tells law enforcement or medical personnel what happened to them, can that be used in evidence, or are you dealing with potential hearsay issues?
The answer is usually not. There are limited exceptions, such as an excited utterance if someone talks about it in the middle of a chaotic situation, or medical records sometimes allow a statement by a patient to come into evidence. But usually, except for those exceptions, you do need the child. You can't just have a police officer come in and say, I met with this child and that's what they told me. That would be hearsay. That would be impermissible. And that's why you need the child's testimony usually. But as I said, sometimes there's other evidence, confessions, other witnesses, medical records that you could construct the case without the child's testimony.
Let me talk a little bit more about what we know about Sarah Sessions. So, according to online records, she has been a licensed teacher in Oregon and worked as a special education teacher at Ponderosa Elementary School during the 2020-2021 school year. And after resigning from her position in August of 2021, she continued her career at Evergreen Virtual Academy in North Bend. At the time of this alleged abuse, Session had specialized training in caring for children with special needs, although it's kind of disturbing to think about what she's accused of now. And her personal life has also come under scrutiny because she apparently has 3 children, including a stepchild from her marriage, filed for divorce from her husband in 2022. And during her time at Ponderosa Elementary, there were no complaints about her conduct that were reported. However, I will say school officials confirmed that she resigned after only a year, which could be suspicious, could be strange. Then again, typical for many teachers on contract. Dan, how might her professional background as a special education teacher maybe impact this case, particularly in terms of, I don't know, the public's perception, maybe trying to get a jury for this case? The evidence in this case, how does that affect it?
Well, there's 2 parts of this. One is the proving of the guilt by the prosecutors, and then there's the sentencing component if there is a sentencing. So in terms of proving guilt or lack of guilt, I don't think their other work will really be helpful, because if someone had this stellar history, if that's true, and then if it's true that these allegations happen the way they happen, then that's not going to excuse this conduct at all. Oftentimes, though, working with children, such as you mentioned, having a long track record without accusations, that could lead to a lesser sentence, and often that's used as a mitigating factor in sentencing. Although with such egregious accusations, it's hard to imagine there being much mitigation.
But if she had specialized training, I think that's something prosecutors mentioned in an opening statement within the first 2 minutes, no?
Certainly, they want to establish that this is someone who they knew how to care for people. They were trained how to care for people, and that can argue against the defendant saying that this was a mistake. I didn't know what I was doing. It was an accident. Although, again, the type of accusations you're mentioning, forcing someone to eat vomit, all this sodium being consumed, someone without training wouldn't do that either. So I don't think it's ultimately going to be a major issue, but it may come up in the proceedings.
Talk about proceedings. So Sarah Session and her father, Gary Hardenberg, they appeared for their arraignment on Monday. They made separate appearances via video from jail. Sessions' bail was set at $1 million. Her father's bail was set at $75,000. So you're seeing a different degree of the charges here and the accusations. But during the hearing, the judge also imposed a no contact order. So it prohibits both of them from contacting the victim, contacting other children in the case, even certain family members. During the hearing, the father of this child, the father of the victim, Christopher Session, he tearfully addressed the court. He is separated from Sarah, resides in another state, and he spoke about the devastating impact that this alleged abuse has had on his family, describing how it has left his children traumatized. And he expressed his deep sorrow, saying that his children now live in fear of Sarah Session and, quote, are afraid that she will come and take them in the middle of the night or hurt them or anyone who tries to stop her. And his emotional statement underscored just the profound effect this case has had on his family.
Miss Sessions' abuse of my children was willful and extremely heinous. The impact of her crimes has caused serious physical and emotional harm to myself and my children. My children remain fearful of Miss Session. All of my children have been robbed of their childhood innocence. The emotional, physical, and financial repercussions of the crimes that she has committed will last for years. The children and I are asking that Miss Session remain in custody until she can face a jury of her peers and pay for the atrocities that she subjected my children to.
Meanwhile, the attorney representing Gary Hardenberg, Todd Grover, spoke of the long-standing nature of this case, suggested that it will likely go to trial. He emphasized that his client, who's apparently a retired engineer, has no criminal history. He was not a flight risk. He also highlighted the family's tumultuous situation, noting that the Hardenbergs had been involved in a complicated child custody battle regarding Sarah Sessions' two biological children. He also explained that the grandparents had been unable to see their grandchildren for nearly a year. Now, in response to these strained family dynamics, it appears that, or at least it's been alleged by the attorney, that Gary and Paul, they had taken a trip. They were staying in an Airbnb. They were arrested. But according to Grover, Gary experienced this, quote, mental health crisis during the trip, and this led to him being hospitalized before his arrest. This is all based on reporting also from KTV Z21. But Grover also argued that the Hardenbergs, they hadn't tried to evade prosecution. They pointed out that they had proactively reached out to the district attorney's office in an attempt to voluntarily surrender, but Grover claimed the prosecution and authorities, they'd opted to just have them arrested instead. And he also noted that one of the charges that Gary's facing, first-degree criminal mistreatment, appears to be the most serious charge, carries a presumptive probationary sentence. Now, as for Paula Hardenberg, she didn't attend the hearing, but court records show that she was arraigned the following day. Details of that hearing not totally clear at this time. But what I will ask about is, Dan, when you think about this, the $1 million versus the $75,000, father-daughter, what are the factors that typically influence the setting of bail in a case like this, and why do you see that discrepancy?
The main factor is whether someone's a flight risk, and you set bail in order to secure the person having the willingness to come back. If someone has to put up $1 million in cash or bond, they're going to come back to court more likely. If someone puts very little, it's more likely that they will leave without paying. So if someone is facing a long sentence, often you will set a higher bail because they have more reason to flee. If someone's facing less time of incarceration, maybe you can have less bail amount because you don't feel that they have a high likelihood of fleeing. If someone's cooperating with law enforcement, it's another reason to have lower bail. That's sometimes a reward for those negotiations that will set bail. You'll be released. You won't be incarcerated. So those are some of the considerations. Also, dangers to the public in certain jurisdictions is considered as a factor in bail, and that might have been considered here.
Did any of those potential circumstances laid out by Gary Hardenberg's attorney, do those factor into the bail analysis? And maybe more importantly, do they factor into his potential defense at trial?
Well, certainly the willingness to cooperate with law enforcement, willingness to surrender, those types of things definitely lead to lower bail because it shows I'm not looking to run from this. I'm willing to face these charges. The danger of someone fleeing is really the main reason someone sets high bail. So the lawyer, I think, was making that argument to show the person is cooperating and that they're not responsible for the more egregious allegations here.
And then the no contact order, victim, children, family members, is that typical?
Absolutely. You're never going to see a case like this where there is not a no contact order. Anytime anyone's accused of domestic violence, child abuse, there's definitely a no contact order that usually extends beyond just the victim, but to their family. Also, that's essential in any prosecution like this.
The statement from Christopher Session, the parent father of this victim, making such a tearful statement in court about the effects that this story, this alleged abuse has had on his children. How does that factor into the court's decision making? How does that maybe preview what he might testify to at an upcoming trial?
Well, it certainly seems that he's adverse to this defendant in a way that may lead to him testifying in a way if he has information that's helpful. But certainly when there's ever an accusation of a caregiver abusing a child, the question often is, well, do they have children in their home? Are they taking care of those children? And what do you do about that? Even if there's no allegation of abuse there, certainly it's a danger to have someone continually living with someone who has been charged with such an egregious action, such as this child abuse scenario that you've talked about. So I think that's not going to lead to additional criminal charges, but there are a lot of lives that are really hurt because of these allegations that go beyond just the person who was the main victim in the charges from the prosecutors.
Now, they haven't taken pleas yet. There is a court hearing on the docket for March for them to enter pleas. How likely is it, you think, Sarah Session would be offered a plea deal? Maybe her parents offered plea deal in some way to reduce the charges, because you have to imagine they're going very, very strong against her considering what this child allegedly went through. I'd be shocked if anything was on the table that wouldn't consist of significant prison time.
Right. And that's one reason why it would be surprising if there was a quick plea deal. If someone is facing significant prison time, prosecutors are generally not just going to offer something less immediately. And a defendant who is facing a lot of time doesn't have an incentive to make a quick deal because they want to see if they can, through the course of the events, maybe witnesses lose their interest in cooperating, maybe other evidence doesn't seem as persuasive, maybe the child doesn't seem that they're going to testify. So for a defendant, it's often worth waiting. Usually these cases don't get stronger over time. They get weaker, and the defendant may hope that that happens, although here there seems to be a mountain of evidence.
The judge has set plea hearings for Sarah Session and her father, Gary, for March 17th. Paula's plea hearing hasn't been scheduled as of yet. This is one of the more disturbing cases that I've seen in quite some time. Dan Schorr, thanks so much for coming on. I know this is not easy to talk about, but I appreciate you breaking it down for us.
Thanks, Jesse, and I'm glad you're covering it. It's important for people to know about this, and it's always good to talk with you.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe and check us out on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.